We got sovereign citizen in court currently in custody serving 120-day jail sentence. Things didn't stop. They're now facing 2 additional felony charges, each carrying about 3 years after allegedly running from police attempt to avoid 4-month sentence. At some point you got wonder how things keep getting worse with every decision.
It's going to call a group of cases, All People versus Matthew Kafori, 25T53, 24T75, 24T392, 24T368, 26CR10, 25M153, 25M154, 26CR5, 25T108, 25T233, 24T275, All People versus Matthew Kafori. Counsel?
Catherine Decker for the people.
And Your Honor, Daniel Gagarin from the Public Defender's Office on behalf of Mr. Kafori on all cases today. However, Mr. Kafori, as I informed the court staff, Mr. Kafori did indicate that he wishes to waive counsel. And so
Also had at some point, and it's hard to keep track of with all these cases, ADC appointed on some of them. Do you know, Jetta? I'm asking you a tough question. All right. We did have ADC on some cases.
It looks like at one point it was Jeanne Villalobos. They're actually on the docket with her name, the ones that have them. Do you want to see the docket?
Yes, thank you. Actually, I've got mine. All right, Mr. Gagarin, that's your understanding is Mr. Kafori wishes to waive his right to an attorney today?
that is my understanding, Your Honor. I have been appointed to the 2 felony cases. I thought Ms. Lyle had been appointed to all the misdemeanor cases, but Mr. Kafori informs me that he wishes to waive counsel on all of his cases. And so I discussed with him the advisement that the court would go through for that.
All right. We're going to start, Mr. Kafori, and just advise you, I know we've gone over this for a number of these cases. 2 of these are at least your first appearance on these cases. You do have the right to remain silent and do not need to make any statement. Any statement you do make can be used against you in court. You do have the right to be represented by an attorney throughout your case. If you cannot afford to hire an attorney or you remain in custody, you have the right to ask the court to appoint one for you. Any plea you enter must be voluntary and not the result of undue influence or coercion. You have the right to have bail set in your cases. You have the right to have a jury trial. If in 2 of these cases, I believe you do have the right to have what's called a preliminary hearing. A preliminary hearing must be set within 35 days of the filing of charges or after you demand it, if you wish to demand a preliminary hearing. The purpose of a preliminary hearing is to determine if there is probable cause to believe that the offense charged has been committed and that you are the person who committed it. From this point until final action in your cases, you are prohibited from harassing, molesting, intimidating, retaliating against, or tampering with any witness to or victim of the acts charged. If your cases involve domestic violence, you're prohibited from having contact if already ordered. I will let you know that there have been 2 additional cases that I don't know if you have been advised on. The first of them is 26CR5. 26CR5, the district attorney filed a felony complaint information indicating 3 charges. Count number 1, vehicular eluding, a class 5 felony that on or about December 29th, 2025, Matthew Mark Kafori, while operating a motor vehicle, unlawfully, feloniously, and knowingly eluded or attempted to elude Jonathan Roy and or Austin Minicho Sikora, a peace officer also operating a motor vehicle, when the defendant knew or reasonably should have known that he was being pursued by the peace officer and operated his vehicle in a reckless manner. That carries a possible penalty of between 1 and 3 years in the Department of Corrections. Count number 2, driving under restraint. On or about December 29th, 2025, Matthew Mark Kafori unlawfully drove a motor vehicle upon a highway with knowledge that the defendant's license or driving privilege was under restraint in violation of sections 42.2, 138.1a, carries a possible penalty of up to $100. Count number 3, reckless driving. On or about December 29th, 2025, Matthew Mark Kafori unlawfully drove a motor vehicle or a low-power scooter in such a manner as to indicate a wanton or willful disregard for the safety of persons or property in violation of section 42.4, 1401 CRS, that carries the possible penalties of up to $300, up to 90 days in jail, or both. In 26 CR 10, the district attorney filed a felony complaint and information in that matter, alleging 3 charges. Those 3 charges read the same, but they indicate that they were on January 14th. Count 1, vehicular eluding. On or about January 14th, 2026, Matthew Mark Kafori, while operating a motor vehicle, unlawfully, feloniously, and knowingly eluded or attempted to elude Deputy Brett McWilliams, a peace officer also operating a motor vehicle, when the defendant knew or reasonably should have known he was being pursued by the peace officer and operated his vehicle in a reckless manner in violation of section 18.9116.5 CRS. And then, like the other charges I read to you, it also includes a count of reckless driving and a count of driving under restraint, both alleging that it occurred on or about January 14th of 2026. Do you understand the charges in those 2 cases as I've read them to you?
No, I don't.
I'm inclined to believe him when he says that, especially given how poorly thought out whole situation appears, essentially, he tried Dodge Jefferson County misdemeanor jail sentence, ended up turning it into much worse outcome by picking up 2 additional felonies in process.
Today I'm appearing sui juris and propria.
Well, I'm going to tell you really quick, Mr. Kafori, I just read those charges out loud to you. Do you understand those charges? If you don't understand those charges, I'm not going to allow you to go forward without an attorney. I want you to be represented by someone who understands the charges. Do you understand the charges as I've read them?
I understand the charges as you have read them. Okay.
All right. Do you understand the rights that I read you in regards to all of these cases, including your right to silence, your right to counsel, trial, bail?
Yes, I do understand those rights, Your Honor.
All right.
I do have some statements
Now,
that I would like to make in regard to the advisement that you just gave me.
Now let's talk a little bit more about your right to an attorney. Is it correct that you wish to go forward without an attorney in these cases?
I would like to reserve all my rights, and today I'm waiving my right for counsel.
Okay. For today's purposes?
Yes, sir.
Okay. Now, some of your cases do have we believe that there was alternate defense counsel appointed on them because of your failure to appear some time ago. I don't know if they are still in those cases, but in regards to those cases, do you understand that Ms. Villalobos would represent you in those cases?
I would like to waive my right to counsel in those cases as well.
Understanding that you do have the right to remain silent, you do have the right to have an attorney. Well, let me just ask a little bit more regarding your right to counsel. You state you do understand your right to have an attorney and you wish to waive it for today. Is that correct?
That is correct.
When you waive that right, well, is this your knowing and voluntary decision?
Yes.
Are you under the influence of anything?
No.
Are you thinking clearly?
Yes.
Has anybody made any threats or promises to get you to do this today?
No.
Do you understand that I will appoint counsel if you want an attorney to represent you?
Yes.
Do you understand the charges that I indicated on those 2 cases, and that the other cases involve charges that include possible jail time in the county jail? Do you understand those possible penalties, including up to 3 years in the Department of Corrections in both of the new felony filings? Do you understand those possible penalties?
Yes.
Do you have any legal training?
I do not. No.
How far have you gone? How far have you gone in school?
I have a high school diploma.
According to him, being able read, write enough justification, represent yourself court, instead relying on properly trained, experienced lawyer who would clearly handle case more effectively, frankly raises questions about level education he received, because that line reasoning doesn't exactly reflect strong critical thinking or understanding how legal system works.
Speak to the public defender any further before you make this decision here today?
No, I don't.
Do you understand criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
Yes.
Do you understand that that while you have the right to represent yourself, but that by doing so, you take a great risk of not properly presenting your case or your arguments?
Yes.
For this hearing, at least, knowing all of this, is it still your desire to represent yourself?
Yes.
All right. I think a couple of things we need to do. I've advised the defendant on the charges, Ms. Decker, and so I think on those cases, I need to ask him how he wishes to go forward, whether he wishes to have a preliminary hearing on those matters and have those set for it. I do think we need to address bond in at least some of the cases, and he does have the right to have a 48-hour bond hearing in those charges, or he does have the right to have a bond hearing in regards to those new cases at least, and some of the traffic offenses. I think I'm obligated by law to make some changes. But do you agree that that's, Ms. Decker, that how we at least minimally need to proceed today?
Yes, Your Honor.
All right. Mr. Kafori, you stated that you wanted to speak to me. Now, understanding your right to remain silent and anything could be used against you, what is it you wish to talk about here today?
Okay, Your Honor, for the record, I'm appearing sui juris and propria persona under special appearance only to challenge the jurisdiction of this court. I reserve all my rights and waive my right to counsel. I have not seen a writ of habeas corpus for my production, and I do not consent to this video appearance under Rule 43. The 13 warrants have never been served to me. I believe I am currently being held in a legal black hole 31 days past the 48-hour mandate that you just mentioned of CRS 16-4-102. Today, I am challenging jurisdiction. I would like the dismissal of all charges, the return of my vehicle that was illegally seized, and these charges to be dismissed with prejudice. There's a multitude of due process violations that have happened. I'm 31 days currently past my Rule 5 advisement and the 48-hour mandate for bond setting, which is quite some time. My vehicle was illegally searched and seized for me on April 1st out of Aurora off of private.
Well, that's what tends to happen when someone runs from police. As for claim about possible rights violation regarding not addressing bond within 48 hours arrest, that requirement only applies when delay would actually cause prejudice defendant in this situation, since individual already being held on 120-day jail sentence. Any delay addressing bond on new charges would be considered non-prejudicial, therefore not valid issue.
Investigator Natalie Stowe came and visited me on April 8th with a search warrant dated April 8th from a looks like a senior judge in Jefferson County to seize my vehicle and some property in it. But this warrant was dated 8 days after it was actually searched and seized. It was searched and seized April 1st, forcefully from me in Aurora on private property. I was held at gunpoint and arrested, and that's when the vehicle was taken. There was no chain of custody between that day and April 8th when this warrant is dated. I don't know where it was. I assume it was in the hands of the Gilpin County Sheriff's Office. There's no record of what was done in between. It was not impounded. It seems like they just took it and had it dropped off in their own parking lot. So there's no record of of anything in between the day they actually searched and seized it and the day they got a warrant to search and seize it. That is a clear due process violation under the 4th, 6th, and 14th Amendments of the United States Constitution. I would like an explanation for all of that today, first off, and because of those violations.
We can set all those matters for a hearing. I'm going to advise you again, Mr. Kafori. I don't know if you want to talk about these facts and these situations today. As I mentioned, there's two things we're going to address. We're going to address whether or not bond should remain as set, and we're going to address what your next court date's going to be.
Okay,
do you wish to address the court regarding either of those questions?
Why was the 48? Why are we 31 days past the 48-hour mandate for bond setting?
And Judge, may I withdraw?
Yes, Mr. Guillen, thank you for your time.
Thank you.
And
So you're complaining that it was beyond the 48 hours, correct?
yes, we're 31 days past that currently.
Anything else?
For me,
Yeah, any other argument regarding bond?
well, I'm challenging that the court has no jurisdiction. I said that I do not consent to this video appearance per Rule 43. I have a right to be there in person. And I would like the immediate release of my vehicle that has been stolen from me.
All right, I don't have any authority over that. I have authority right now over these criminal matters.
Okay, I would like an explanation why there's a 31 delay on my bond hearing and my Rule 5 advisement pursuant to CRS 1640.
Asked, answered.
All right. Ms. Decker, any position regarding bond or anything you wish to advise regarding bond?
The people's request would that the bonds remain as set. I believe they're $25,000 cash only with these numerous cases to include these 2 vehicular felony eluding charges the defendant presents as a community safety risk. So that's the position on bond, and we would ask to set for preliminary hearing.
Review the cases. I don't necessarily know why there's been the delay, but the statute regarding the 48-hour bond hearing requires it to be within 48 hours, but it does not provide any sort of remedy if it is not within 48 hours. The court then needs to weigh several factors, including the safety of the community, the other principles and factors for bond, the reasons given or not given for why that was not complied with, as well as any prejudice to the defendant. I'll note that at the time, a request for a virtual writ was issued on Mr. Kafori's behalf by his attorney through the public defender's office, and that's why we're here today with that virtual writ. That was dated some time ago. I do review, and after understanding the cases, the likelihood of the defendant's appearance in court as required, the safety to the community if there's not a cash-only bond, the safety to the community, as well as any prejudice, which I find there is no prejudice, and that the defendant is also being held in Jefferson County on a case in which he did appear. He is facing a sentence, and so he's currently serving a 120-day jail sentence, and was addressed then that there is no prejudice in regards to this matter. I am going to deny modification of the bonds on the 26 CR 5, 26 CR 10 case. Those are the largest of the 2 bonds. Here's where I do have to, by statute, modify bonds. Okay. On 24T317, that will be modified to a personal recognizance bond.
I'm sorry, what was that case number, Your Honor?
24T317.
Thank you.
24T75, 24T392, 24T275, and I can update all these for you, Jetta, when I get to them. 275, sorry. The 25T53, and 25T108, all of those cases, all those bonds in those 6 cases will be modified to personal recognizance bond. The court denies modification of any other bonds at this time. Mr. Kafori, do you wish to have a preliminary hearing to test probable cause in the 2 new felony charges?
Your Honor, I am solely here to challenge the jurisdiction of this court. That's all I'm here to do today. Once jurisdiction is challenged, everything else really needs to be.
Have you taken a look at where you are, what you're wearing right now? Because jurisdiction seems pretty clearly established if you believe that simply challenging jurisdiction going pause your case, maybe for surprise, could end up sitting jail well beyond that 120-day sentence while court takes its time addressing any jurisdictional arguments.
And the due process violations are unconstitutional.
The court finds that it does have jurisdiction over these cases. These cases were filed here. Affidavits and arrest warrants were issued out of this court. The court finds probable cause and does have jurisdiction. Your next argument?
How does the court can determine its own jurisdiction? Is that correct?
No, I made a factual finding. I have jurisdiction, and I made so in each of those cases.
Okay.
Do you wish to have a preliminary hearing? You must demand. You said you didn't want to waive any of your rights. What I'm going to do is I'm going to set you for a preliminary hearing. I'm going to ask that the district attorney writ you to be here in person as you have requested to be here in person. Let's do that June 1st date.
1:30.
June 1st, 1:30 for preliminary hearing. All other matters will be set for a continued arraignment. Mr. Kavori, you said that you waived your right to an attorney as for today. Is that,
Yes.
Do you wish?
I don't consent to any of the proceedings of this court at the moment. I believe
I understand. I'm going to appoint the public defender to represent you at those hearings. They can file a motion or a request for attorney.
Objection, Your Honor. Is that practicing law from the bench? Is that what you're doing right now?
No, I'm making a finding that you are not in a situation to be able to handle your own defense. We can talk about it then. You can waive your right then. I don't want to waste any more time with you, Mr. Kafori, and find out that at that point that you do wish to have an attorney. So I am appointing them. They can file any sort of
So you're practicing from the
motions
bench.
regarding that prior to that hearing. So at the the June 1st hearing, we will see you at that time. June 1st, 1:30.
Nothing changed with my capability between 10 minutes ago and now, just for the record. So you determined that I was, able to represent myself about 10 minutes ago, and now you're not. So
You told me you wish, Mr. Kafori, you told me you wish to represent yourself for purposes of this hearing, and you did not wish to waive any other rights.
Yep.
So for purposes of this hearing, I allowed you to represent yourself. We'll make that decision at the next hearing if we need to make that decision at the next hearing.
Okay, and I'm requesting that the court approves jurisdiction over this matter. That has to be established.
I have no proof requirements. However, we are setting this for a preliminary hearing. The district attorney does have has to meet a burden of proof. That's their job, not mine. Thank you.
Okay.
We'll see you on January. We'll see you on June 1st. What's that?
I said I'm glad that we established it was incumbent upon the district attorney and not yourself.
No thank you, because without sovereign citizens being as determined as they are argue these points ID, have find new answer age-old question which one us actually smarter. That's end video. Well, likely seeing this individual again few weeks. If you enjoyed video, hit like button. If not, hit dislike. Either way, drop comment, subscribe with notifications on so you don't miss any my content.